Okay. We're looking at 2-2 notes today. It'll be in your Google Classroom. And there's a lot of stuff there. So if you go to your book, it starts on page 34. What we're trying to do is talk about trial procedures. We talked about all the courts and the jurisdiction last time. Now we're going to talk about trial procedures. What we have is a couple different things. We have criminal charges brought up by the state and the town, Urbandale, state of Iowa, versus so-and-so. But we also have what's called civil cases, where individuals believe they've been injured by another party and they want to sue them. A lot of times these are expensive, so there's some alternative ways to handle this, and so they call them alternative dispute resolutions. It's just a popular way of trying to resolve disagreements outside the court system. Okay, so it's another way of deciding how to make a disagreement go away or to make a settlement in unique different ways. They call them ADRs if you want, and then there's a chart on page 35 that has reactive and proactive ways. Reactive ways are the most popular. This mediation, arbitration, or a combination called MED-ARB. There's other ones called early neutral evaluation, summary jury, private civil jury, but we're not really going to discuss those much. The main ones we're going to concentrate on is mediation and arbitration. Mediation is when two parties I'm suing you, and we involve a third party to help us, that's called a mediator, find a solution. So we invite them to come. They listen to the reasons behind the disagreement. They try to come up with a compromise from both parties that they would be able to agree upon. It is not binding. If you don't like the mediation, you don't have to listen to it. But arbitration, it's the same type of process where two parties have a disagreement. They bring in this third party to try to resolve the situation, but the arbitrator, not the mediator, this time it'd be arbitrator, is wanting and is going to make a decision that is binding. All right. MED-ARB is a combination of the both. They try to use both aspects of this reactive alternative dispute resolution, the best characteristics of both. But mediation is inviting a third party that makes suggestions, help them summarize, come to a compromise, but it is not binding. Arbitration is the same thing as mediation, except it is binding. The third party is binding. Proactive, on the other hand, is trying to find solutions that will make sense, where they're trying to agree maybe ahead of time. They're trying to understand methods before or solutions to problems that might arise at a later situation. So they're doing it prior to this situations. We have these different contracts, which are sometimes getting to be a problem, where you can't, you agreed to sign your salary contract, and in the salary contract there's a thing about how you can't sue them. So it gets a little bit out of hand. But proactive is trying to set up methods of dispute resolution prior to them coming up, saying we agree to do this, we agree to do that, we agree not to do this, we agree not to do that. A lot of it is about trying to, it sometimes is more pro-company than pro-employee when looking at the business. But reactive is after the fact, and so that's the difference between these two. All right, so these are options if you can't go to court, if you don't want to go to court, or prior to court. You see some of these in movies and television where a mediator is trying to listen to both sides of the story and such. Okay. If these aren't an option, or if they're not possible, then you would go into what is called a civil court, a civil case. And you would have what is called, the beginning of the trial is civil cases, pleadings. These are papers that are filed by both the plaintiff. If I'm suing you, I'm the plaintiff. And if you're being sued, you're the defendant. So these papers are being filed. The first one, and you can find these on these page numbers, I think it's actually 36, not 37, but there's a picture of the complaint on 37. But the complaint is papers that express what the plaintiff's allegations are, in the form of like, on this date, this happened, this defendant did this, this is why we demand XYZ. Usually it's money or, being paid back and pain and suffering or something along those effects. So the complaint is filed by the plaintiff. The answer is filed by the defendant. And the answer is just the defendant's response to this complaint that happened. And you can find both these definitions on page 36. There's pictures of the complaint on 37. There's a picture of the answer where the defendant would state, this is incorrect. They didn't answer. They didn't left out this part. This is why it happened, and I'm not going to pay or whatever. Methods of discovery are used to bring the facts before the trial. They'll say maybe depose or interview witnesses, have questions answered based on maybe some documents. Let's say there's a accident report, where you would have the report from the police officer or an insurance company, physical doctor, medical exams, things like that. Those are all discovery facts that would be methods of discovery, bringing these up and trying to get these out. Maybe we can force the defendant to make a decision about this prior to going to court. They're trying to bring the facts out before trial. Now, then we move on to what's called a pretrial hearing. This takes before the trial. Basically, it's an informal meeting. They talk about the issues, discuss what's going to be happening. And in this case, sometimes you make motions to throw evidence out, things that might not be used in the court, and somebody might want to use it. So you find reasons in old court cases and precedents that would say, no, we're not going to. It embarrasses the member. It has nothing to do with this case, even though it maybe goes to character or something. So that's all happening in the pretrial. When they get into selecting this jury trial, what we end up having is we need to be able to select a jury. And so they have a little process, and there's all these different shows on that you can tell. Basically, you don't need to write anything down for that, but we select a jury, pool of citizens that kind of try to listen to the facts and understand it as best you can. You got opening statements. We'll see that in the movie a little bit later, explaining what they intend to prove and as the plaintiff, intending to prove this is what happened at this date, this is why they're responsible. The defendant's opening evidence would obviously try to contradict what the plaintiff's evidence is and try to propose alternative possibilities or reasons why their client, the defendant's not guilty. Introduction of evidence. This is starting on page 40, 41. There's a variety of different things going on with this evidence. So in the opening statements, usually the plaintiff goes first and talks about it, and then what they talk about in the opening statement, they will provide evidence for. Evidence can be contracts, like we said before, written reports by police, anything you buy or emails, text messages, evidence, whatever it can. Some of these things they call affidavits. They're sworn statements. You could get subpoenaed, where you would be ordered as a witness to come and appear and testify, where you're subpoenaed and say, yes, I know this information and this is what I saw or whatever. You can have expert witnesses come, a variety of different things. This is a semester-long class. Evidence is a big thing, but we're just talking about the main ideas, right? Any kind of documents that support their evidence, any kind of phone calls, emails, communication, reports, witnesses. You can get a sworn affidavit, that's a statement, or you can get a subpoena, that's a statement, and making them testify in court. Once both sides have done this from the opening statements, then there's a cross-examination, asking the questions, trying to poke holes at this evidence. So if there's a report saying this happened, you might get a witness and try to make that previous statement a little less effective. You get a witness to try to, on a cross, try to weaken the other party's case a little bit. You might get expert evidence to come around. You might get somebody that would show favorable reasons why something happened, and you try to cross-examine in a way that would present your case and weaken the previous arguments that were done. They can cross-examine these defendant witnesses. I said I saw this, and then you can say, well, what time of night was it? Where were you? Were you under the influence of something, and try to get them to not look as expertish. Okay. We do a bunch of this, obviously. This could go on, depending on a court case, for an hour. If it's a very simple case, it can go on for months. It's a very difficult, involved case. It just kind of depends. Once everybody is introduced evidence, we've cross-examined, we run out of witnesses and documents, they go into closing arguments. Plaintiff attorney again goes first, present closing arguments. The defendant is second. It summarizes all the evidence, tells the judge and jury why you should find your defendant guilty or not guilty, whatever the case may be. Jury gets instructions. Sometimes it's complicated. Sometimes they're based on just you can only listen to one thing or this thing, and so the judge will give the instructions to the jury. Not much that you don't need to really write anything down. That's just part of it. Some of these terms are important for us. We want to know what a verdict is. A verdict is when the jury goes to a jury room and deliberate and come upon a decision they make. It's a verdict. They will be in favor of one party or the other. Obviously, different types of juries do different court cases, have different preponderance of evidence. You have to prove beyond a reasonable doubt, prove beyond 50%. More likely, it just kind of depends. But a verdict is when a jury deliberates and then they come out with a verdict. A judgment then is the jury. Following the jury's verdict, they will issue a judgment. So the verdict might be guilty of second-degree criminal mischief. Well, there is a length of time for a fine, length of amount of money, minimum to maximum, restitution. There could be jail time. There's minimum and maximums, and the judgment comes down with that. The decision of it's going to be the maximum fine. It's going to be a middle of the road fine. It's going to be probation. It's going to be restitution, and whatever the case may be. All right. Remedies for different things. All right. One of the things in civil court, a remedy is just why, what are we going to do to fix the problem? So if the defendant's found liable, I sue you guys for vandalizing my house. You're found guilty. Then you're found liable, you're found guilty of that. And so there could be payment, there could be actual things that you have to do. And so these things, specific performance or injunction. Specific performance would be the plaintiff may want the defendant to do what he or she promised in the contract, known as specific performance. You have a contract with somebody and you say, hey, I want, you were supposed to deliver these goods. You never brought the lumber to my house so I can build my deck. It was shoddy. You need to supply real good, the real wood that I asked for. So they would be forced to do a specific performance. But there's also things where the plaintiff, if they won, they would ask the defendant not to do something. They want them to prevent them from doing something. And if that's the case, that would be considering an injunction or something that would order these people, the defendant, to stop doing what they're doing. If you're in the neighborhood and you have a restaurant or a bar moves into the neighborhood and they're loud, they're in the back and they're violating those ordinances, or a hotel or whatever, there might be something you seek an injunction. You can't do this after X, Y, a certain time, or whatever the case may be. Okay. So specific performance would order somebody to do something as a remedy. Injunction would be to prevent them and stop them from doing things. There's a good chart that kind of talks to you about different things throughout this chapter. You can take a look. Sometimes it gets a little confusing, but if it keeps you you can kind of help some people. It kind of helps visualizing this. That you can look at those charts. This criminal trial procedure is very, very similar. There's some similar points. We'll go through it a little bit, but this is when, if I was to do something and you get arrested by the city, then the state charges you with a crime. This is when two parties, civil cases, and like I said before, is when two parties disagree. This is more around a criminal. So the arrest is when you take somebody and you read them, rights. You give them a warrant. You might have a warrant for their arrest. You deprive this person of their freedom, especially if they committed the more serious of offense. There might be things like bail, or it might be just that they go in, you read them the rights, you arrest them, you release them on their own recognition to come back. If there is such a thing as an arrest, you don't always need a warrant. There's an accident happens, you go, you see him happen, do the crime. You come and there's, the crime's already been committed. You witnesses tell you you don't need a warrant to arrest somebody, but you'd arrest them, take them to jail. The rights of the defendant, a lot of these are brought about in the Bill of Rights that we talked about last chapter. The Miranda rights was brought up, and basically it's from something that happened in a long time ago in the 60s or 70s. I can't remember. Might even be longer. I have the court case. We used to read it, but it requires certain things to be told to those being arrested so that they can understand their rights clearly. And it was based in a court case in Arizona. You have the right to an attorney. You have the right to make a telephone call. Now, these things don't obviously have to happen right away. There's going to be processes. You have the right to remain silent. Okay, some of these things. What is bail? We kind of mentioned it before. You get arrested, it might be a misdemeanor. Okay, you get charged, you get let go. Or there could be a felony or a very serious crime where you have bail. And what bail is an amount of money that are value, something, property, possessions that you put up in order to get out of jail. And then you're able to go and assure the people that when you're released, you will actually return for trial. You'd lose that money. So if bail's set at $100,000, I think bail is usually 10% of what that number is. So then you'd have to come up with 10% of whatever the bail money is, and then you get out. If you don't, you got to stay in jail. And then it's just a kind of a secure deposit kind of deal where you say, hey, yes, you got to put this money up, then you'll come back to court. If you don't, you lose that money. All right, and then you obviously would get in trouble for that too. There's seizure, plain view type things that we can discuss. Officer Wilcock come up and kind of talk to us about these things. Basically, there's different reasons why you can be searched. You can have things taken off your property. They call them quick frisks. You can see if they're holding something. If you're in a suspicious, in a situation where there's a crime being committed and you're one of the bystanders, if they might be able to try to ascertain that the safety of everyone's there, so they might be frisking people. There's a lot of reasons why and why not. They can search cars, things in trunks, things under seats, things in glove boxes. They can make limited searches with their view of what they have. They used to be able to impound your car because you committed a crime, but they didn't want to search it. They couldn't find anything. So then when they impound it, one of the rules is they have to do an inventory of the contents so they don't get sued for stealing something. So then what do they get to do? They got to search a car. So there's a variety of ways for this. There's a variety of reasons you can get pulled over. There's certain judges that will kick out if you fought that case. You kick it out and say, no, that wasn't a reason to pull somebody over. But there's tons of things. Hanging something from your rearview mirror could be a reason. It could glare and distract other drivers with the sun, and you can say that's a reason. You can have a tail light out. You can have not a sticker on your license plate. There's just thousands of different reasons. Okay. The plain view rule is police may seize anything without obtaining a warrant if it's in the plain view of the car. Now, again, Is a glove box plain view? Is a locked armrest in plain view? Um, they talk about different reasons, and we're not going to get into all the different specific, that's illegal, this isn't illegal. It's just there's a plain view kind of rule that is in effect. And this goes around with those amendments that we talked about, that Fourth Amendment, where you need, you got to have probable cause to search me. You can't just come into my house. You got all these different rights. But there's a lot of different reasons why police might have probable cause. If they get probable cause, then they can search a little bit more. Okay. Once a motorist gives police permission to search a car, officers can open containers, bags within that car. If you have a cooler of beer in your car, but you don't have any beer cans, and the whole car smells like beer, that's probable cause. Even though I can't see beer cans, I can get out of the car, search your vehicle, open that container, especially if you give them permission. 1,000 different ways to get in and out of this plain view stuff. And again, you don't really need to have all the different, well, this is not right, this isn't right. Just as long as you kind of understand what plain view means, that police can seize items that are in plain view without a warrant. And then there's different reasons they can get probable cause so that they can search your car, okay, or your house, or your garage, or whatever the case may be. Usually we're talking cars for high school kids. Okay, we'll move on. The arraignment will have the suspect or the defendant is brought into the court, and depending on what court you're working on or whatever, they'll have little information sent to the jury. And the one thing we might have when there's an arraignment, they make the idea of what the reason the complaint is. The defendant has its rights, and then there could be what's called a grand jury setup. Okay, at this time, at the arraignment, before the grand jury is brought in, they could dismiss the case. They can say we're going to go on and present some evidence to a grand jury. And so what the grand jury is just a jury made up of citizens who might decide whether there's enough evidence to proceed with a case. That is for more probably serious situations. So you have a grand jury, and it's made up of people who decide, is there enough evidence or not? Are we going to take this court, or is this just the state trying to, doesn't have enough evidence to charge this person? So the grand jury, again, this is not a perfect, they have to be unanimous. They give you the information saying, yes, this is enough to go to court, or no, you need more. Okay. They have different things like a petit jury, a trial jury, all these different things. But really, in what we're looking for is this is just kind of a hearing that's not really made public. You're trying to get a racketeering case made against somebody. You present the evidence that you have to some jurors, and they have to sign some papers saying they won't talk about it, and we get to see if they have enough information or not. That's kind of what we're looking at. If you get into the grand jury and they say yes, they listen to it, and we believe that there is enough evidence that a crime has been committed, then you can go and issue an indictment, and you would get what's called an indictment, a written charge against the defendant, where there would be charging them with, whatever the crime may be. After that, we would have this, whatever this is, the process. We would have the arraignment where the rights of the suspect or the crime is going to be read to the suspect, and they're going to be asked if they pled guilty or not guilty. They'll be informed of their rights and taken from there. Now, the trial is very similar to what we just talked about before, where you have opening statements, you have the evidence brought forward, you have affidavits, subpoenas, court documents, or police reports, doctor visits, whatever the case may be. All that stuff is put into the trial, and you're going through the steps. Mistrial could be called if the jury can't agree when they hear all this evidence, and they just can't agree on anything, and a new trial might have to be held, and do it all over again. And sometimes people don't want to do mistrial, and during a trial they might, something might happen where they'll cause the jury to just not be able to agree, whatever the case may be. A mistrial just means the trial, the jury can't make a decision, and a new trial can be held if the district attorney wants to prosecute. Um, there's sentencing when you get found guilty, not guilty, or guilty, I guess, then you would have fines. Again, maximums depend on the severity of the case, the degree of, seriousness of the crime. You could be put in prison. You can get out, obviously, after certain times. A lot of times, prison is sometimes there's maximum amounts. Sometimes they say up to 10 years and you get out good behavior in 5, something like that. There's fines, there's imprisonment, there's probation. They don't really talk about probation here, but there's probation a lot of times in less serious offenses. Certain places would have what's called the death penalty. Usually that requires an absolute guilty plea. It usually happens to be on a capital count. We're not going to spend a ton of time on the death penalty here, but these are just some ideas that happen with sentencing. Now, juvenile cases, there's quite a bit of information on the last 2 pages on this. Basically, juveniles are usually cases that are held for people under 18. They might hear at the beginning would hear what's called a detention hearing. That'd be the first step to find the reasons why the accused is in custody, figure out what's going on, kind of like a pretrial. Trying to figure out what is the problem, what is being done, and the judge would be hearing this. You'd have the police, the court, probation people. Maybe there's a social services, welfare, child welfare agency type place, some kind of agency helping give information about the home life of the juvenile, the background, whatever. The judge might put them on probation. They might put them in a different home. They might put them with different relatives. There's a whole variety of different things going on based on all the different circumstances since they're minors. And it depends on the severity of the case. A minor can be charged with a adult crime and does happen. But in juvenile cases, they have this detention hearing first to get the idea behind everything. Usually it's settled in 3 ways. Those are towards the last page somewhere where they talk about usually the person's sent home. They're on probation. They might have to pay a little bit of fine. They might have to go to supervised probation. They might have court ordered, house arrest type thing. Monitoring system, whether it be ankle bracelet, watch, whatever the case may be. You might order the person to a new agency, the juvenile to a new agency, a new home. There's different places where juveniles would go that might get a little more structure. And there's different federal homes around the state that people go to. Some you can go to different academies. There's a place in Eldora, just different things. A judge may also commit the offender to a reform school. That's where we're getting at with that. So foster homes, the place like Eldora, Woodward type thing, or home and probation. So that is 2-2 in a nutshell. Hopefully you're able to follow along in your book and get as many notes as you can done. And we'll go over some of this later and summarize it when we meet again.